Time now is 10 o'clock on February the 4th. Notice of the February 4th, 2016 meeting of the Board of Examiners for Land Surveyors was posted to the Board of Examiners Land Surveyors website on January the 20th, 2016. Call to order. And first thing I need to do is we'll take a look at the agenda real quickly, Board, and is there anything that we need to do or change on the
If there's no other amendments or changes proposed by the board here, I'd make a motion to approve.
And I second.
All right, any other discussion? All in favor?
Aye.
Okay. But what I'd like to do, and I'm going to request that we amend the agenda real quickly, and that is because we have Mr. McCormick budget, and would like to do that and insert that at the present time. The floor is open to budget presentation.
Thank you all. It's good to be back with you again. Brian McCormack, Assistant Commissioner for Regulatory Boards for the Department of Commerce and Insurance. And I think you've all been distributed. Does everybody have a copy of the budget information? Really a look back from, as we try to do annually, give you a kind of an overview of where we were in the previous fiscal year. Also compare that to the last 4 fiscal years. So I'm going to focus on fiscal year FY 14-15 that closed in June. And so just to kind of look at your I think you'll see most of the things are very consistent. Your payroll expenditures are almost identical, travels flat, and then kind of looking at your grand total of expenditures, you're just a little bit lower than the previous year, but basically flat. Moving into the cost backs, your cost backs expenses are, like I said, basically exactly the that, which leads you to a total expenditure in that fiscal year of $187,051. And looking at your licensing revenue, this is really the one thing I did want to mention to you all. As you can see, you all are on the up-down cycle, as they call it, 1 year up, 1 year down. And so we've noticed over the last 4 years that there is a tick down in terms of licensing revenue between the 11-12, you went from 373 to 351, and then in 12-13 to 14-15, you went from 30 to 25. So there does appear to be, it's not a significant necessarily dip in revenue, but it's something that I think is worth noting. As you can see, there does appear to be a trend that your licensing revenue is decreasing, and I wanted to just bring that to your attention. We did look at your number of licensees, and they have, over the last, kind of comparing the year, this in the same way, there's been a small reduction of your licensees, the total number, and that's obviously probably the main reason for your reduction there in revenue. So. I'm glad to answer any more specifics about any other questions, or glad to.
Item really of any concern that we need to be noted about? I mean, I understand there's a drop in licensees, i.e., and then of course that works its way down to loss or a drop in revenue because of that drop in number of licensees. But any other numbers there, red flags of any kind?
No, I think everything else is really consistent. I mean, I think you all are you're managing your organization very effectively, and your expenses are staying very consistent. So really, I just think that's something you're going to want to watch as we move forward. I think as we look at these numbers next year, I think we want to see again where we are at the end of the year for licensing revenue and licensing numbers, and see if that's a trend.
I'll tell you one positive note here with the numbers in terms of the drop in licensees is we've got a stack of what, almost 50 applications over there, which is considerably higher than I've seen in previous meetings. So hopefully there's an upswing, not only obviously with the economy license, and hopefully it'll work its way up as well. So that's positive news.
Two things, Mr. McCormick. One, on the revenue side, we're in a cycle currently where we had additional exam revenue for 2 of our examinations. We actually have 3 examinations. The FS and PS examinations are transferring to CBT. and NCWS handles those fees. So those fees are actually going away from our board. We still have the application fee, but we don't have the testing fee that we did. So there is a change there. The second question that I have, and it's a question I ask every time, so you know what's coming, is I realize that we're 1 year on, 1 year off, and back again. Is there any thought from your perspective relative to changing that so that we basically hit about half of the licensees every year?
I think we do like the 2-year cycle in terms
Okay.
of how we're doing it. I think since you mentioned it, if I could, I wanted to talk a little bit about the renewal process in general. I think one of the things that I wanted to kind of address is we're moving. You all have the December 31st renewal deadline, and I think one of the with all our boards and commissions here and reg boards is to identify how we can, as efficiently as possible, get license renewals completed. And so in doing that, we've, as you know, we're our online renewal system, and we're also looking toward initial online applications across the division for online applications. One of the things we've noticed with the programs that have December 31st deadlines is, particularly if you have work that's required, it becomes very cumbersome for the programs because you have such a spike in that one season that it requires a lot of work that happens right around the holidays. In some cases, as we know, most of our licensees, and it's across the board. And I'm a lawyer, and I do the same thing. I renew the last week or so before, so we just have a huge influx. And we've been trying to identify ways that we can kind of effectively sort of manage that workload, so we're getting folks renewed in a timely manner. And I think it's been a conversation we've been working. Paul and I have been discussing with her group. And so I was just going to say that I'd love to be able to present some kind of things to think about down the road, or you all could have some conversations about how to do that, because one of the things that there are a series of sort of options you could look at in terms of how you could do that. You could decide, and I think ideally for us it shouldn't matter what date it is, because if we do it online, we can do it automated. And I think one of the things that you all do is you have CE, that's the biggest reason for determining whether or not someone's. Some of the programs actually look at ways where instead of essentially that renewal being automatic, and the review of CE can occur after the fact, either through an audit or through a different process. And so what it allows for is your licensees, when they apply and pay, their renewal is automatic, and we found that to be, with a number of programs, a pretty successful method of making sure that you can get that done in as quick a manner as possible, and it doesn't create a long, unless we provide a lot more workers for a very short season, it does kind of cause it's just naturally going to take a little bit longer. And so that was one of the suggestions I was going to kind of throw out for your all's consideration. But just in general, just to say that I think we're hoping to move this process to as customer friendly and as automated for your licensee as possible, so that they don't have to worry about calling or waiting. And so that was just one of a few, but I think we'd love to take kind of an opportunity to sort of pitch some ideas to you if that's something you'd be interested in hearing about. And because I think some of your concern is revenue, but I think some of it is that's a lot at once to figure out how to handle. And so just wanted to throw that out there and see if that was something you all be interested in us looking at.
For years it has been the 2-year cycle thing that we have done here, and in order to keep a kind of an even flow of revenue, and I know Tim was alluding to this, but if we staggered our renewal, if we took A through M or A through whatever half the alphabet is, and they renewed on an even year, and then N through Z on the odd year, but they renew every 2 years, you have revenue coming in every year that keeps it an even flow of revenue. But what does that do to you guys?
Well, I mean, I think it's
self-sufficiency standpoint.
Sorry, and this is Bill Hudson. He's the account manager for the division. I'll let Bill chime in here.
Yeah, I just, what came to mind when you were talking about that was just the self-sufficiency requirements that we have. And with the us, it's just a matter of, we don't want 2 years in a row of a deficit. We can handle one. Two would trigger sunset hearing, so that's one of our big concerns.
But as far as 2 years in a row of deficit, that was one thing, but as far as the renewal, to keep an even flow and our revenue coming in every year, and, you know, instead of one big year and then 1 year with nothing, we just keep it even. Every year you get half of the revenue in.
You'd obviously be a lot closer if, based on your financials here, and we could kind of look into this more, but you're going to be a lot closer to the line if you were doing it that way. I mean, you would be, your margins would be a lot closer in the if you were doing it year by year. I mean, that's I think that's essentially what
Well,
Bill's
I think,
getting at.
based on what Mr. Nunley said, he's correct that with that scenario, the 2-year scenario, it's probably better to have that surplus and then the deficit, and then that way you're not, you know, we don't get in jeopardy of the 2-year situation that you're speaking of.
Gives you a little bit more time to evaluate your financials, where we're not. It gives us a little bit more time to address your financials moving forward.
One other thing, if I may, and I think that we entered a season this year that was quite unusual from the standpoint of just the implementation. We had pay online two years ago, but it was a different scenario than what it is now, and being able to add the CEs to it and so forth. The point I'm getting to is this: it was our understanding at our last meeting, and Ms. Nicole can correct me if I say this incorrectly, that the newsletter that our board typically puts out was kind of put on hold because the department was looking at other things relative to newsletters across all the boards in the department. And I think that kind of hurt us a little bit because we were not able to get out notice to all the registrants of kind of, hey, we've got a new system, and this is kind of some of the nuances and how it works and so forth. And I think that in some ways may have hurt Nicole and her staff in handling a lot of this. And they did a great job. I'm just saying that, sometimes communications with the folks that has to do this is a good thing. And with our newsletter being, in my mind, in limbo or in a hold state, I think that hurt us a little bit.
Sure, and I would agree that communication is critical. I mean, I think we want to make sure that your licensees are getting the correct knowledge. And so I know that, and speaking of this, honestly don't recall the status of where you all are in terms of newsletter, but what we were looking at just in general, and that is to make sure that we're the department is and kind of making sure that the content is reflective of what we would want from all our programs. But no, I 100% agree with you that I think we want to make sure that and what I was saying a minute ago in terms of talking about the renewal process, I don't see it as a necessarily there's a one solution fix to how to make sure we do this process well. I think my thoughts are, we want to make sure that when you get to that point that we've got, for you all, we have 2 years to make sure that the next time we come around, we're doing that even better. And so I think it's a good opportunity for us to work with you to be able to do that in a manner that really reflects what you would hope to see for your licensees.
I appreciate your comments, appreciate you coming and telling us about it, and I'm looking forward to hearing some of these new concepts that you've referred to that we as a board can help, with, because that's what we're here for, try to make it better.
Great. Thank you, Mr. Rankin, for help. Thank you, Chairman.
Thank you.
Right.
Other questions or comments?
Well,
Funds coming in.
hey, well, thank you, board. Really appreciate it. And sorry to interrupt your application review. So I'll let you get back to that. Thank you. Thanks.
Okay. Well, a couple of things that have come in here. Mr. Driver, you are here to make a presentation too. What if we just do this? And you handling the legislative end of the thing?
Yes, sir.
Okay. Then from the director standpoint, I'm going to ask the legislative representative to come and give us a report from the legislative standpoint. Mr. Driver. What did you do to your foot? Went skiing, I know.
No, I stubbed my toe.
Okay.
I'll sit over here. Thank you. Thank you, as always, for having me, board members. Michael Driver, Deputy General Counsel for Regulatory Boards with the department. You're being passed around a copy of the legislation that I've identified, we've identified, that appears to affect your board in one manner or the next. That's currently filed. At least one of those is actually one that was filed last session, because, of course, the legislature runs in 2-year sessions, and so bills that were filed last year are still eligible to be moved forward this year, although sometimes they do fall off between sessions. If you do have a question about any of these, just stop me, let me know, be happy to answer. The first bill is Senate Bill 2594, House Bill 2496. This bill actually affects a number of different regulatory programs, including yours. What it does is there are several programs that say that a board, including yours, can deny for a felony generally. Just as a felony, what this statute does is, or what this bill would do, is say that the board can only consider the felony if it bears directly on the applicant's fitness to practice competently as determined by the board. So the board, in addition to finding that a person had a felony, in order to deny that application for licensure, were this to pass, would have to find not just that there's a felony, but that felony affects or on their fitness to practice as a land surveyor. That one is actually unset. It hasn't been heard in any committee at this point. It's been referred to Senate Commerce and Labor and the House Business and Utility Sub. It's not been put on any calendar as yet, so we've not seen any movement out of it.
If this was enacted as legislation, would our legal department give us direction as to what would or would not potentially apply relative to our profession and our board?
Absolutely, and I will say it does say it affects the applicant's fitness to practice competently as determined by the board. I think there's still, even if this were to pass, I would think that the board's concerns about any given applicant could likely be addressed in those cases. But yeah, of course, we'd provide you any guidance if we felt like a particular felony, say, was tenuous in how it reflected on an applicant's ability to practice. We provide advice regarding that. The next bill is on, I guess, the third sheet of paper. I printed front and back to try and conserve some paper here. It's Senate Bill 1505, House Bill 1613. This is actually your sunset bill. It extends the board to 2021, which is a 5-year sunset extension, which has become pretty standard across these things. It's actually already passed in the Senate, and it's been recommended by the Government Ops Committee on January 26. It'll get set in Calendar and Rules Committee next, which is generally a non-substantive committee, and be put on the calendar for the House to hear it. Don't know when that will be, but that'll be the next step. Again, don't foresee any issues with that one. Next page, Senate Bill 709, House Bill 759. This is actually the one that I was referring to from last year. Currently, it's a exemption to the criminal statute against using drones to take pictures for a person performing mapping. This bill removes that exemption and narrows it to an exemption for a land surveyor who is licensed by you all to use a drone for surveying. It hasn't moved this year. It is still filed. It failed in the House Business and Utilities Subcommittee last year. Has not been reset this year. It's still out there, but again, we've not seen any movement out of this one.
Was there a reason why it failed in the House last year? Have any idea?
I honestly don't know. I'd have to go back and watch that video. I remember seeing it last year, but it's been quite a while. Oh, okay. It was pulled out of the committee. So I assume there may have been some discussion that we aren't privy to that resulted in that happening. I honestly have no idea. Next bill, Senate Bill 2469, House Bill 2201. This is a bill of general interest that we're presenting to all of the boards and commissions trying to. It's not been set yet, but it actually creates a new process for any agency, not just boards and commissions, to annually review all rules and laws pertaining to entry barriers into the profession. And if it's determined to be, I'm going to broaden it a little, but essentially if it's determined to be not narrowly tailored to the purpose of protecting the public, then the board should either repeal the rule or make a recommendation for the repeal of a law. Again, that's on entry barriers. It also allows members of the public to file a petition with any agency requesting that the board do that at any time in between that annual period. So they would file a petition with you all that said, I don't think that this, exam or whatever, is a good entry barrier, and the board would then have to assess that and enter an order, which could then be challenged up in Chancery Court. So again, we've not seen that one moved either. It's been assigned to the House State Government Subcommittee. It's currently unassigned in the Senate. But just one that we are watching. Those are the ones that we have. Any other questions?
With what has been filed also this year?
Most of these have been filed this year.
These were all this.
All except for the drone bill.
The drone. Okay.
The drone bill was from last session. All of the rest of these were filed.
Okay.
This year.
I guess the inclusion of the surveyors was because we had statutory language in ours relative to the felony. It was the reason for the inclusion.
It looks like what they did was they went through and identified a number of agencies, not just within regulatory boards, but across state government, who had general felony denials, and trying to narrow that down to just felonies, reflecting on whatever that profession is. So no, it doesn't appear to have been targeted, just a general search for that sort of language, if I were to hazard a guess.
Thank you, sir.
All right. Thank y'all.
Oh, gets better?
Yeah, well, me too. Thank y'all. It's always a pleasure.
All right.
Thank you, sir.
Thanks. Tell you what, it's coming up on 10:25, and even though we've only been going 25 minutes, I'd like to take a break, and I need to talk with Nicole for just a second. Okay. 10:28, we're going to resume the meeting. We have with us today Mr. William Smith, and he's here to discuss his reapplication to be relicensed in the state of Tennessee. And Mr. Smith, I'm going to let you speak to us as to what you'd like to do, what had happened. We have your application just now, have pulled it out. We're going to take an opportunity to review that while you're here and while we're discussing what you'd like to do. So tell us in general what has transpired and what you'd like to do.
Okay. Well, thank you for allowing me the opportunity to speak to the board. I guess really just kind of reflecting back, I mean, I've been surveying now since '84. My stepfather was a land surveyor. He got me started in it. So I've been surveying for quite a while now. I was able to obtain my license in 2003, in which I went on and started up W.T. Smith Land Surveying, and had, I don't know, 7 or 8 employees working for me at the time. I've done several land development projects. I've worked with all municipalities, Davidson and surrounding counties, in order to get things approved and put to record. I mean, I feel like I've pretty much run the gamut of just about every kind of surveying that's out there. But in 2007, just with the economy going the way it was, I decided to get out of the business. I was a little frustrated. I had some clients, no pay. and I decided that I need to step away from it. To be honest with you, I was just a little bit burned out on surveying, trying to keep a business going. So I opted to get out at 2007. At the time, I was going back to school. I went to work for another surveyor, helping him out with some land development projects during the day and going to school at night, and got a degree in computer programming, and got into that for a couple of years, from the years of about 2009 to about 2011. And decided that I really wasn't content with that. That's not who I am as a person, that I really enjoy surveying, and wanted to get back into surveying. And so just through the whole process of trying to get my license reinstated has been somewhat challenging, to say the least. I'm not really sure exactly. I mean, I think I took the test. I know I took the test again. I think it was in 2011. I'm not sure about the date. I think it was the fall of 2011. Maybe it might have been 2010. Can't really recall right offhand, but apparently I didn't pass. And I'm not a very good test taker. I never have been. I approached the test incorrectly. I forgot you should always go to the end of the test and start with the points that count the highest. Well, I ran out of time, so the test that was given to me, the state-specific test, was I was unable to complete it in time. So just through the frustration of that, and just trying to get my license reinstated, I'm not really sure. I'm not even sure. I know I talked to Nicole. I was rejected July to make application of 2015. Apparently, I didn't comply with the 2011 standards of practice. I went through the book and compared the surveys that I had submitted, and it appeared that everything was on there that needed to be on there for it to comply with the 2011 standards. So I'm not really sure what the holdup was there. And then with talking with Nicole, she advised me to get her a couple of more surveys that would comply with the standards of practice for 2011, which I did, and submitted those to her. And I guess really in hopes that perhaps the board would take that into consideration and allow me to either, ideally, I would like to have my license reinstated. That's why I'm here. I know that there's guidelines and ordinances that have to be followed, and I'm prepared to take the test again. So I guess really my question to the board is, at this point, what can I do? I mean, what is the what would be the best way to approach this for me? Like I said, it has been a little bit frustrating for me at this point, considering I've been doing this so long now. My son's getting into it. He's wanting to serve. He's wanting to get his license. So it's a generational thing for us. And right now I know a lot of registered surveyors, and right now I'm just doing sub work to them, just doing their field work and CAD work on the side. So I'm actively surveying right now as it is, not doing any surveys under my license, of course, but doing surveys for other land surveyors. So that's where I'm at. I know that this is the profession that I would like to continue in, and so at a really high level, that's really why I'm here, is to see what I need to do or what can be done.
Well, we're taking a look. Tim has the application now, but obviously apps and went on. We go as we were just starting all over from scratch again, and reapply and retake. Unfortunately, every time that one does that, the exams become to be more geared toward that individual that graduates from college, and rather than the apprentice type programs that we've had in the past. So each time you sit down to take an exam, it becomes probably more and more difficult unless you have gone that route. But you already have a degree, so you're familiar with this to be tested in school, and having seen this exam 7, you think, or 10, somewhere in that neighborhood. So you're familiar with the difficulty, the degree of difficulty that's on that exam. So we're going to take a look at this, and it'll be a few minutes. We'll discuss this while we're sitting here, and then we'll talk about it.
Thank
Okay?
Thank you.
Anybody that's got anything else? Take just the state specific again to be reinstated, okay? Old as dirt, isn't he? I ran into him a week and a half ago, so, yeah, like that guy. He's a nice fella.
Mr. Smith, I was the gentleman that basically indicated the denial on your previous application because of the date of the plats and so forth for the standards. Our statute says that the plats must be current and they must meet the current standards. And you had submitted either in '06 or '08. So that was the reason for that. And I've reviewed, the rest of your application was fine. I reviewed what you've resubmitted, and I find no issue with it whatsoever. And if the other members agree, then you would be able to sit for the April examination. And of course, you know, examination's up to you and how you do. But I think you have completed what we requested, and you know, I'll turn it back to Mr. North.
I want to thank you just for coming in to at least say, hey, this is why I'm doing this, and at least say I have that thing right here in the front of my mind, and I'm ready to get on with this program. And I regret that things weren't up to date to begin with. Otherwise, it would have gone on through. But taking the exam, I got a fellow working for me, and let me tell you, it's not a piece of cake anymore. And so just apply yourself to it and get through the thing, and then you come back. So look forward to getting a good grade.
Be that way when you're taking the test. Remind you don't take a test. Mine needs water. If you don't know the answer to a question, go on to the next one, and then you come back
You're
to
going
that.
Okay, is there anything else then, Mr. Smith? Have we covered what you need to have covered?
No, sir, that's it.
Okay. Thank you for taking your time to come down and meet with us, and we're ready for the quiz. That'll work. Nicole, is there anything else that you need as far as your particular report? I think, Josh, do you have something, if we go ahead and get yours out of the way, then you don't have to stay in here, or you're going to have to stay with us?
He has to
Probably-
stay to the end of the meeting.
Yeah, I'll probably have to stay regardless, but we can do it in whatever order you wish.
Why don't we just go ahead and get the legal thing out of the way, and then the rest of it, we can get, and we can call you back in, Nicole, and we'll just say on the camera while we're on camera. You're welcome to stay for that. You don't have to, but anyway,
Congratulations, Dennis.
congratulations, Dennis.
Yeah, that means you're buying lunch today, right?
He said we can go anywhere to McDonald's and have anything on the dollar menu, right?
Right, that'll work.
Taking on some new responsibilities.
That's great.
Good.
That's great.
Absolutely good.
Great.
Appreciate that. Okay, let's go with the legal report, and Josh, I'm going to turn it over to you. Excuse me, Mr. Kilgore, I will turn it over to you.
All right, that sounds good. Only two matters on the legal report today, and do you all have that on your iPad? Okay, well, that's fine too. Have that in front of you. I'll go ahead and start with case number one, which is case number 2015-021-7461. This particular respondent had one prior complaint that was dismissed back in 2010. This complaint was received after complainant had obtained a civil judgment of $10,000 against the landowners who used this respondent to survey land and determine the boundary lines between their and complainant's property. Complainant was out of town, and when he returned home, he found the lumber had been harvested from his land without his approval or knowledge. Defendants based their conclusion of where the boundary line was based on respondent's survey, which was shown to be erroneously done in court. Respondent ignored a natural monument called for in complainant's deed and instead used tax maps to determine the boundary and ignored an old fence row. Complainant's expert witness and surveyor in court testified about the deficiencies in respondent's survey, and the court found in complainant's favor. Respondent was not named a defendant in this matter, but the record shows that his survey was improperly conducted, which led to the damages against the complainant. Therefore, my recommendation is that we authorize formal and send a consent order with a civil penalty in the amount of $1,000 for misconduct in the practice of land surveying.
So if I understand your recommendation, you're authorizing a formal hearing, yet if the respondent signs the consent order and pays $1,000, that's it.
Yes, sir.
Well, I'm gonna go ahead and speak. I'm gonna go ahead and throw my feet in the fire. This is, as presented, is probably one of the most egregious things that a surveyor can do or not do. It's the way I understand as written, what the respondent situation that has been created. It's my opinion, and the members will give you theirs, that the recommendation is not severe enough, and it's my opinion that this raises the level of the penalty to a suspension period of the license,
Okay.
included with some ethics training as well. Now, that's my opinion. I'm certainly open to whatever time that, if the other members agree, whatever time that they may feel would be appropriate for this suspension. But I think that this is way beyond what I feel like, and no disrespect to you, Josh, what I feel like would be a minimal penalty. But again, it's based on how this is written and how it's presented. And,
Right.
That's, you have to present what you get from the case reviewer.
Yeah, I mean, this is all from the order of the court, and it was a pretty extensive order prepared by the judge. And when I read it, I mean, it spelled out exactly, what happened in the testimony of the other land surveyor. So, I mean, it seems that he did ignore the natural monuments and went by tax maps, which was improper, and ignored
Well,
the
it's
fence row. So I mean, I'm not against a suspension period. I just was going by, I mean, I have to just kind
I
of pull on.
Understand?
What-
When you have a formal tied to a consent order, and it's something that, in my mind, is reasonably egregious, then the amount that goes with it needs to be substantial, such that the respondent clearly understands that if they decide to not apply with the consent order and go to the formal, then there could be full jeopardy there, worse than what the deal you already offered them. And so that's one of the reasons too that, like I say, as stated, this is one of these situations. If this complaint had been brought to your legal department prior to it going to court, we would have probably had to dismiss it pending the court decision. But now we're getting the complaint after the decision, and it seems rather clear that from the other side's expert witness and surveyor that the respondent has made a pretty grave mistake. So that's why I feel like it rises to that level.
Right, and I'm not disagreeing with you. I mean, I'm perfectly open to whatever the board wishes to do as far as a penalty. So, it's ultimately up to the board. I just make the recommendations, and if you disagree, then we go with the board's authorization.
Yeah, I'm right there in line with Tim with what I understand that he's saying here. Again, we're given a paragraph of what happened here, and even in the limited information that's provided, just the errors and from what I read, just a nonchalant way of surveying is completely ignoring the fundamental basics of surveying, and it scares me that there is somebody out there, a licensed surveyor, performing surveys in this manner, and what a detriment that is to the public. And our primary responsibility is to protect the public here. And if this surveyor is out there, having already performed one survey in this manner, who knows if he's performed others? I think it behooves us to absolutely, do something stronger than just a civil penalty here. I did see that is the maximum civil penalty that we can issue, and I'm in full agreement with that. But I can't imagine that we can stop there. We've got to get something done here on this surveyor's license if this is what he's performing. I see at least a suspension on the license. I think absolutely some mandated education on basic boundary surveying. I mean, from what I've seen right here, that's just going off a tax map? Seriously?
Good.
And ignoring a natural monument? I mean, that's Survey 101. I think we need to at least initiate some sort of action for a suspension in his license, mandate some education before he can get the license back.
Okay, so how long would you wish how long would you wish the suspension to be?
Surveyor, no matter what we decide, the surveyor would still have an option to go to a formal if
Yes,
they
sir.
so saw fit, if they
Yes, sir.
disagree with what we decide.
Right. So we're offering
Yeah.
him an option to either voluntarily suspend his license for a period of time or go to a formal hearing wherein, it could be more severe and
Right.
he'll be assessed court costs and everything else. So,
Right.
yes. And that's all standard. I mean, suspensions and the farthest that we could do as far as what the board recommends today would be voluntary revocation of his license, but at which point he still has an opportunity to come for a formal hearing.
What type of corrective education would amend the problem?
Well, there's plenty of courses available on boundary surveying, which I think this is really what it boils down to. It was a boundary survey, and from what we can tell, and from the court's decision, it was insufficient. Best. I would suggest, Tim, Galen, at least an 8-hour course in boundary surveying, perhaps 16 courses in that. As far as a time frame on suspension of someone's license, what I really don't like is taking away someone's livelihood for a length of time, and that's essentially what a suspension of a license would do. It negates his ability to make a livelihood, assuming that surveying is his profession and his sole source of income. Those employed by his license, under his license. So I'm really not in favor so much of a length of suspension on the license as so much as it should be suspended until he can prove that he is taking these 8 or 16 hours, whatever we agree on boundary surveying of courses that are approved by this board.
But I think we would have to provide some reasonableness of time. In other words, for example, just let's pull a number out of the air. It doesn't mean anything right now for discussion. If it was 6 months, where does he go? I mean, I look at it both sides of the coin because, Josh is going to have to deal with it, whatever it is, and obviously a year would probably be too long, but is 3 months adequate? That's kind of my thought scenario right now. What would be a reasonable time period for somebody from the time that they receive Josh's letter, but they actually have 30 days to reply, don't they, Josh? So in other words, for example, let's say Josh sent them the letter Monday, then they have 30 days to reply and say, I'll do this, or I'm going to want a formal hearing.
Right.
You request the formal hearing, then he's not going to be suspended.
Right.
Obviously, during that. I mean, we can't force him to not work. So, if I may, I'd make a suggestion that perhaps we do offer him voluntary suspension of 6 months or until such time as he can prove that he's completed the, 8 hours?
I'm like Jay. I would say 16
16
hours of boundary courses satisfactory to this board.
Right.
Yeah, I have to agree with both of you guys. I think 16 hours, we learned surveying 101, as Jay put it. I do have a question concerning the expert witness. Was that expert witness our witness that talked about this? That was one that was just brought into court concerning this. What did our expert say on this particular thing?
I didn't send it to our expert because I was going based off of the order of the court. I mean, it's already been proven and settled in court. There's not.
Sounds like the court's decree was pretty clear.
Yes.
Yeah.
Yes.
And in that case, I think we're absolutely right in mention, be it 90 days up to 180 or until this education taken care of and that civil penalty.
Here's what I would propose. What I would propose is the full $1,000 civil penalty, just like you've already outlined for us, and a voluntary suspension of his license until he can prove that he's obtained 16 hours of board-approved boundary surveying coursework.
Yeah, the only question I have about that, and I see Nicole kind of eyes going from left to right, is do we need to approve what he takes before he takes it, or does he just take it and submit it, and we find out that it was, a course provided by a 1, 2, 3 provider that we don't even approve to start with? That's my only concern about the coursework. I think we're on the right direction with it. I certainly would not want, and you spoke to livelihood earlier, Jay, I would not want an individual to try to comply with what we're asking and then fail.
Right, I agree.
That's the only thing. So, and I think Nicole, that's where Nicole was going, was that it might be good if we could direct them. Of course, obviously, we don't know where this individual lives or whatever. It'd be nice if we could direct them towards something. And obviously, it couldn't be a college. I mean, it could be a college course, but if it was a college course, they wouldn't be able to probably even touch that until June. Yeah. So see that puts a little bit of a problem there also.
Don't we have the already approved list of PDH providers, though?
Yes, we do.
Yes, we did.
Yes.
So could we do it on there? I'm assuming that certainly in that vast list of PDH providers, that there's 16 hours of boundary coursework available. I would certainly
Yeah.
think so.
Yeah.
Can we do
I
that?
think that would be fine. I think that's probably the best way to say it, Jay.
I think so.
Yeah.
For the point of discussion, would something time, like really short, but just a definitive amount of time so that it's on the record, and then it'll continue on until they complete the course. They can
I see your
complete
point.
it in that 5 days, great, but
Yeah, I certainly see your point. My main concern really there is the initiative, number one, is for this person to obtain the additional education. That's my initiative number one. Length of, if you mandate a minimum of 5 days, 10 days, whatever, I just, to me, that is a financial burden on himself and the employees that are subject to his license, employed by his license. And in a sense, puts a hardship not only on him, because he's the one in error here, but those that work under him as well. I see your point, though. I absolutely understand. I just think we need to mandate that the emphasis here is getting this surveyor's education updated on the coursework for boundary surveying so that so he takes the initiative to correct his faults, not the fault of those that work under him or are subject to his.
It's-
Well, then you get the amount of the days of the course, 2 days and until.
Well, it's my notion that if we send this gentleman or lady, whoever it may be, this, as Josh phrased it basically, or any form thereof, I mean, when we're talking about suspension, that they're gonna go to formal.
Probably.
And that's fine. And that's fine. And then, all the eggs are dumped out on the floor and we see what's going on.
How would you like me to word it? Are we putting a
I would-
time frame, or are we just
let me
saying
ask you a question.
voluntary suspension until such time as he completes the 16 hours?
Let me ask a presumptuous question before we go there, Josh, if I may. Let's assume that that's the way it goes and the surveyor or the respondent says, I want a formal hearing, okay? At that time, would you then send this file to our case reviewer so that that person would then be an expert witness in the formal proceedings? I'm just, that's a little something I'm a little concerned about, because that was their whole mission and purpose in life and having them. And now it's sort of after the fact, after we have ruled on, not to say that you've told us anything wrong. I'm not saying, I'm just trying to think this thing out a little bit. I'm playing devil's advocate, I
Yeah.
guess.
No, I mean, we could send it to him, or if, we could bring
Subpoena
in,
the other.
we could subpoena the other expert.
I didn't want to get, what I'm saying is, I didn't want to get the cart in front of the horse and cause us a problem when, if the person decides to go to formal and we're sitting here with the judge and the whole 9 yards.
Right.
And then the other attorney says, well, you did this after the fact and brought this person in or
Yeah,
whatever.
I mean, and I think the order could be entered as an exhibit. I mean, that's.
I'm not trying to do your job, certainly.
No.
I don't even know
I
how.
understand that. I'm just
Yeah.
saying, I don't think, no case is perfect, but this one seems to be pretty clear cut. I mean, they've already been to court and had findings of fact, and I don't really know what he would argue other than, try to beg for leniency, but it appears that he's definitely done, wrong as far as surveying. So, I would feel pretty confident about going to a formal on that. Not that I would be the one litigating it, but I would feel confident giving it to a litigator.
Okay, well, give us your motion then again.
Okay, so as I understand it now, we've changed the recommendation to $1,000 civil penalty in addition to voluntary suspension of the license until such time as respondent can show proof that he completes 16 hours of PDHs and boundary surveying, which are on the approved course list as approved by the board.
How do we manage? Question here is, how do we manage? All right, let's assume that Josh sends the letter to the respondent, and the respondent signs a consent order March 1, for example. Okay. Now, how do we manage this suspension time from the standpoint of notification to anybody. For example, on our search a license on our website, it should say that this individual is suspended. Okay,
It
so I
should.
mean, so how do we manage that so that
It'll
not only the respondent is aware, but the registrar in his county or adjoining counties or whatever, somehow or another there needs to be some management of it that, hey, look, this person does not have a license to practice, and that's why that I feel like that there should be a timeline tied to it. And then, because then we as a board can, or you as the legal department can release that.
Well,
once
we'll
that's
release it
approved.
once he sends us proof that he's done the courses. But until that time, his license will be, as soon as we receive the signed consent order, his license will be in suspension. And that's a status that we have on the computer where it'll say, and it'll show to the public when they look up his license that it's in suspension.
My notion is it's not gonna stop him from working wherever he's at.
Well,
If he would do this,
yeah.
if he would do what this says, he's not gonna stop working. If he agrees, he's not gonna stop working, and nothing is gonna change on his part. But clearly, he's in his own jeopardy. I mean, that's his own decision if he does.
Well, yeah,
continue
I mean,
working.
if we find out, unfortunately, that's the way it is with any board when you're talking about suspension or revocation or anything. If they can still somehow convince someone to use them, that's in their own jeopardy. But if we find out after the fact that he signed this order and he worked during that period where he was suspended, then we're talking about revocation. And that's what I would bring to the board as my initial recommendation. If this individual came up again, I wouldn't be talking about fines or suspension. I would definitely be talking about, well, your offer is to either voluntarily revoke your license, or we'll just see you at a formal where we'll, be seeking revocation of your license.
There's really not a whole lot you can do other than a public entity like on the website, publish that the license is suspended. And then if and when it gets, validated, that it gets updated on the website. But there's nothing that you can do to the registrar or the general public to inform. There's just no way. But it's there available to the open public on them to go check on the status of his license.
Well, the only reason I
and that
mentioned
it's
the
up to them.
registrar is because I remember that in times past, that if a person's license was revoked or suspended, that a letter was sent to the register of the county of where they reside, notifying them that that person's license had been revoked, for example.
I think we could do that. At least to the registrar in his county.
Yeah, I think that would be appropriate because, that's the person that's going to see something trafficking more than likely. Yeah. So basically, we're at voluntary suspension until such time that he completes 16 hours from the approved course list, along with the $1,000 civil penalty.
Specifying exactly what 16 hours has to consist of. It has to consist of the boundary surveying, right?
Boundary surveying and boundary law, because they're sort of synonymous in a way.
And that lets him surveying only, then.
Second that.
All right, any other discussion? All in favor? Aye. Opposed? Okay. Motion carries.
Right, and our second and final case number 2015-01-8861. This one was a consumer complaint alleging that respondent conducted a survey and put markers on her land that failed to account for 6 to 8 acres she claims is hers. It is apparent based on respondent's response and the evidence that respondent did not conduct the survey, and that to avoid any conflict of interest, he hired another licensed surveyor to do the survey. Therefore, any complaint should be opened against the surveyor who actually performed the work and not this respondent. Therefore, my recommendation is that we close while establishing another complaint against the proper party. This was one just from a consumer landowner, and she happens to be adjoining landowner with this respondent who happens to be a surveyor. and all indications are that he tried to comply with the law by not performing the survey and hired a licensed surveyor, but she's just confused as to who actually did the work. And she's claiming that he came out and put stakes where that's on her land, and it's just basically a boundary dispute. But if there is anything to look at, I would definitely send this out to the expert reviewer against the other surveyor who actually performed the work. But I don't see anything to hold this guy accountable or liable for any violation of our laws.
Do you know if he produced a formal signed sealed plat? Or was it just he went out there and put some markers on the land?
Well, whoever did it, I think her allegation is he just went out there and put some markers.
Well, now, let me clarify something. Nowhere in the paragraph does it say that the consumer and the respondent are neighbors.
Yeah, but
But you said that. I just want to make sure that I heard that correct.
yes.
And because that totally changes my understanding of what's written here, knowing that fact. Because I was totally confused when I read this, because it said he hired another surveyor. I'm trying to figure out who he was. Well, now I know he was the respondent, because I know the respondent was next door neighbor to the complainant, which I didn't know that. So that's what I was trying to figure out. So I guess your conclusion is probably correct to a point, except do we really want to close it? Let's just say, for discussion purposes, that the surveyor that the respondent hired did in fact make mistakes or whatever. But there was more of a connection to that with the respondent than appears at the face up. So do we want to put the respondent in where we can't go back and revisit this particular complaint?
Well, we can revisit it if we're just closing. If we were
Okay,
dismissing, then it would be dismissed.
I never remember those from time to time, Josh, and I apologize, because we have so many different little
Yeah,
nuances.
I mean, yeah,
and that's the only reason I said that.
It's a fine point, but I
Okay.
mean, closing is just, well, there's not enough evidence here for me
Okay.
to say that there's a probable cause that he
Well, I can,
violated our.
I can agree with you. That's
Yeah.
not a problem. I just want to.
Yeah.
I just want to make sure, just in case.
But if we
the second
discover
case
new
came back,
evidence, yeah,
that we could.
No, we're not
Okay,
limited.
revisit. Okay.
Yes,
Okay.
yes.
Well, based on that, I'll make a motion that we close this case per the attorney's recommendation.
Second.
Motion made and seconded. Any other discussion? All in favor?
Aye.
Opposed? Okay.
That's all I had on my legal report.
Case,
Well, are you going to speak about the other items that are on the agenda, Josh?
As far as let's see, at the last meeting, we were discussing the GPS standards rules, and I believe I had presented those. And those are making their way through the process of rulemaking. It's a slow process, but they're going to be sent up in a justification memo and make it through legal, and then sent on to the AG's office for pre-review, et cetera.
So the moral of that story is, because we have language in our standards of practice that says we're to determine things, we have to determine things by rule.
Well, I think we adopted it as a policy last time, but we discussed how a licensee can't violate a policy. That's just kind of a guideline. But as rules, that's the way that you could actually get to discipline if we have a complaint come forward against, something that would be in violation of those GPS standards. A rule would be the only effective way by which the board could, take action. So, yes.
I just hate it has to be that way, because we're now going to be that much further into the process before we actually have any teeth to it. So the moral of the story is we need to look at our standards and see if there's any other places, and I know of at least one right now off the top of my mind, that says it's to the board's, what the board says. Look at those, and any of those places, we need to be crafting some kind of rule relative to that so that that's not the case.
Yes. Yes, with regards to surveyors, I haven't got any new information on that. I mean, I know that when I first took over this position that there was a lot of discussion about it. I took it to my supervisors, and we asked the local government committees how they interpreted that, and generally they say it's a good practice, but they don't have to use it unless there's, I believe, their practices, they use it if federal money is involved as far as awarding to on a qualified basis, not on just the cheapest bid. And then I know Jay had sent me something in an email regarding another state's, and you had linked, I guess, their rules and in relation to how you saw them dealing with some qualifications. And they had some criteria set out, and I did review that. However, I think that their statutory scheme is different from ours, so therefore their rules are obviously different. So basically, I mean, I'm kind of at for lack of a better word, a dead end on that, because it seems like, based in my interpretation of the statutes, that we would have to rework a lot more than just rules if we were going to. I mean, it would be kind of like revamping the entire rules, I guess. And a lot of theirs was from statutory language that was kind of mirrored in their rules. And I don't have a definitive answer about, who can force someone to bid under the QBS standards and who doesn't, because from what I got from the municipalities was, it's a good practice, but if there's not federal money, then we don't really have to do it that way.
Well, part of the thing was we were not specifically mentioned as other professions were, and that was I guess that's the elephant in the room is if we are part of that underlying language as a professional. And if we're not, then probably legislation is in order to get that taken care of.
Right. And I think legislation, or at least some kind of clarification from someone other than, I mean, it would have to be from legislation or an AG's opinion on whether or not surveyors are included in that. And I mean, I read it as that we can be, as far as professional services and construction activities, but that's just one lawyer's opinion, and that doesn't carry a lot of weight. So
Is it, I guess, in that spirit, is it worth the effort of asking the AG that question?
yeah, I mean, if the board wants to get the AG's opinion, we could certainly ask for.
That would basically tell us whether we needed to look at legislation or not, or someone look at legislation. What do you think, Jay?
Well, it's certainly worth pursuing. I agree with Josh, although I'm certainly not an attorney's opinion by any means, but although in practice and in reality, it is not, which is the whole gist. Basically, we're going to be at a dead end unless we either push for an AG or go legislative. Arduous at best. But I think, unless we ask for an AG opinion, we're just going to sit here and spin our thumbs. So I certainly
motion on that for you, Josh?
Probably just put it in the form of a motion,
Okay.
and we can say that the board authorized it, and then I
Okay.
can take it.
I'll make a motion that, that our legal department respectively ask the AG for an opinion on QBS with regards to surveyors and how it may be applied.
All right, motion made in a second. Any other discussion we need to have? Favor?
Aye.
Opposed? Okay, motion carries. Of PDHs.
That was the complaint report, yeah.
Oh, that was the regular complaints, okay.
Yeah.
Back to us later if you need
Could,
it.
yeah, could I
Yeah, you can come back.
please get that email printed off? And
Okay, sure. Us, Dennis, I don't have anything else that I think we need to cover right now, and that kind of frees
Do-
Nicole up to do whatever. And
Okay.
you got something else you want to?
I was just going to ask if Nicole wanted to touch on anything on her report. I only have one question about it.
Not right now. I'll save
Okay.
the last of the director report items for.
Why don't we then turn off the recording and we'll go back to applications.